NewJeans contract termination and what lawyers have to say about their case. This video is just going to focus on the legal aspects of the NewJeans contract termination, although they have made some really smart moves, and how they can be good in their favor and what can go against them. And lastly, how this can make some major changes in K-pop industry. I will discuss their strategy of contract termination. First smart move they made is, instead of filing for an injunction, they announced their contract termination on late night Thursday conference. How this works in their favor because NewJeans decided to end their contract outright instead of going to court to temporarily stop the contract, which is what an injunction does. According to legal experts, this is a smart move because it lets the group keep working on their music and activities while they deal with the legal issues. If they had filed for an injunction, their work might have been put on hold until the court made a decision. Many netizens were asking questions about how they can keep working on their schedules and work independently, just not with Ador or Hybe and their brand deals after announcing contract termination. And according to lawyers, there's no operational freeze in this case, and this move allows them to work without interruptions, while Ador and NewJeans sort things out legally. And we can see NewJeans have already moved to Japan for several schedules spotted with staff, managers, and security at the airport. Lee Hyun-gan, an attorney at Seoul Law Office, said, "While it is rare for the weaker party in a hierarchical relationship to initiate termination, there is no legal basis that limits this right to the stronger party." Ro Jong-jin, an attorney at Joan Law Firm, said that the termination takes effect from the moment it is notified and applies retroactively depending on the lawsuit's outcome. And according to an attorney at Joan Law Firm, when NewJeans announced they were ending their contract, the termination became effective immediately. However, whether the termination is legally valid will depend on how the lawsuit plays out. If the court later sides with NewJeans, it's as if the termination was valid from the moment they announced it, and choosing not to file for an injunction indicates confidence in winning any potential lawsuit Ador might file to confirm the validity of the contract. So even though they're a weaker side in a hierarchical relationship with Ador, by announcing the contract, they showed confidence in winning. This move can go in their favor in court. Also, the timing of this press conferences was another smart move that worked in their favor. Some industry insiders think NewJeans held their press conference at that specific time to shake things up. It happened just before Ador's deadline to respond to their earlier warning. By doing this, NewJeans might be trying to weaken the contract's power and stop Ador from controlling things like their advertising deals and TV appearances. Next question that lots of people have: can NewJeans really free themselves from Ador? Okay, so contracts between agencies and artists can only be ended in certain situations. According to Uroojy, he explains that if trust between the two sides is completely destroyed, if the relationship of trust is irreparably broken, the contract can be terminated regardless of who is at fault. Attorney believes that based on what we know so far, based on current information, there's a strong case for termination. NewJeans says Ador treated them unfairly, didn't protect them, and according to the publicly available information, especially a lawyer pointed out Hybe internal documents in which they supposedly mentions plans to abandon NewJeans and start fresh. Lawyer thinks this kind of statement could be seen as a serious violation of Ador's responsibility to take care of the group or its artists. But not everyone thinks the same. Some experts believe it might be hard for NewJeans to prove that Ador broke their agreement. Ko Sang-ruk at PIL law firm says that the 6 demands that NewJeans made, like bringing back former Ador CEO Minji and apologizing for disrespecting Hanni, might not be enough to justify ending their contract. For the termination to hold up legally, NewJeans need clear evidence showing that Ador is directly responsible for these issues. On the other hand, Hybe comment about getting rid of them can be in their favor, but they don't have such a strong case unless they have evidence and more to argue about, other than getting ignored incidents. Next question is about the group's penalty payments. NewJeans claim they shouldn't have to pay any penalties because they believe Ador broke the contract first. But legal experts say this will depend on whether NewJeans can prove Ador was at fault. So for now, their claim is just their claim because Ador also said in their statement that their claims are baseless. Even if NewJeans is found responsible for breaking the contract, the massive penalty amounts being reported, around 400 to 600 billion won, might not be fully enforced. Lawyer said courts often reduce penalties deemed excessive. So courts reduce penalties if they think the amount is unfair or excessive. And 300 to 450 million United States dollars isn't a small amount for a 20-year-old. And question about the group name. The name NewJeans belongs to Ador unless their contract specifically says the group owns it. As the girl said, they are not going to give up on the name. But Lawyer said that even if NewJeans wins the legal case, it would still be hard for them to claim trademark rights unless the contract explicitly gives them ownership of the name. And name belongs to the label, and in some cases, if the idols or group have good relations with their company, they can reach an agreement to let them use the name even after a contract termination. Like Icon owns their group's trademarks after leaving YG Entertainment. And Infinite is still promoting under their group name after leaving Willem Entertainment. And in 2022, GOT7 made history as the first K-pop group to ever become a self-owned group. But I don't think that would be possible for NewJeans because they don't have good relations with Ador. So I don't think they can win ownership of the group name at all. And they possibly have to rebrand themselves. Larry Ko said even if NewJeans wins the case, it would find it difficult to secure trademark rights unless a specific clause grants them ownership. Now, lastly, what Ador can legally do next, although Ador hasn't announced what they plan to do next. But experts think they might do two things. First, they file a lawsuit to confirm that the contract is still valid. And second, they would request a court order like an injunction to stop NewJeans from working independently. There's also speculation and possibility that Ador might try to link NewJeans' decision of their contract termination to Minji. And this move can work in their favor because we all know Ador and Hybe accused Min of trying to take over Ador. So people believe she has influenced NewJeans. How this can work in their favor. If there's proof that shows Minji had a hand in NewJeans' decisions after she left Ador, it could lead to a lawsuit in Ador's favor. And this would be for tampering, meaning third-party interference in a contract while it's still active. Specifically, if Min was involved in NewJeans' actions during the contract, it could be seen as illegal interference. Two attorneys have different opinions on this. Attorney Rowe said, it would be difficult to prove tampering solely based on conversations between NewJeans and Min. Concrete evidence of plans and actions would be necessary. So Ador would need some solid evidence if they're going to use this card against NewJeans. But Lawyer Ko pointed out that even if there's no clear proof of Min's involvement, the timing of events, her resignation from Ador and NewJeans' contract termination, could hurt NewJeans' case. He explained that these events might look suspicious in court and could be seen as a negative factor, even if there's no solid proof of tampering. Such developments could be viewed unfavorably in court, even if tampering cannot be definitively proven, Ko said. But NewJeans' legal team have already thought about this possibility, and they are aware of it. That's why, during their press conference, NewJeans made it clear that they did not discuss their contract termination with Minji, and they said the same during their live conference because they know this can be used against them. The industry is cautious about NewJeans' decision to end their contract on their own without going through proper legal channels. This already is a big thing and can cause some major changes in J-pop itself. Kind Report said some are fearful that if the court rules in favor of NewJeans, it could encourage other artists to try to do the same and leave their contracts whenever they want, which would make it harder for agencies to invest in artists. One executive from a big K-pop agency warned that if NewJeans wins, it could make agencies reluctant to sign artists in the future, fearing more risk. A favorable ruling for NewJeans would heighten risks for agencies investing heavily in artists, potentially discouraging future investments and altering the contractual dynamics between agencies and artists. Although NewJeans' situation is unfortunate for the fans, and the industry and I love their confidence, but let's be real for a second. Ending a contract without following legal steps is hard to justify. We have witnessed 50-50 very public lawsuits and their legal failures. And now NewJeans. On Reddit, I read this question. Somebody said why new groups from fifth generations are going against their companies and acting as spoiled brats. Without anything spoiled, that can actually be seen as a mistreatment. We haven't seen this with groups from second or third or fourth gen groups. You can answer that question in the comments section because I want to focus on the consequences of this and how this really can affect the industry in a wrong way. First, if other groups get influenced by NewJeans, they're going to lose the interest of their investors. This pop industry isn't just about music. It's a business and heavily dependent on investors and are publicly traded. This means they offer shares of their company to the public and investors can buy and sell those shares on the stock market. And Hybe stock dropped by 4.08% on Friday. Then a 2-day losing streak continued. At one point during trading, the stock price fell to 189,301, the lowest it had been in over 3 weeks. When a group from a sublabel of a company like Hybe suddenly and recklessly announces their contract termination, especially without any official company disclosure, it's bound to mess with the company's image. Investors hearing about this from the media instead of a formal announcement could totally impact the stock price. It's not just about NewJeans here. The whole situation affects the company and investors, and everyone's at risk of losing money. NewJeans is getting called out for that, while some argue that it's really Hybe's responsibility to handle the investors and the low stock prices, not NewJeans. Opinions are definitely split, but the big takeaway is that this could affect other groups too, even if they're not involved. It can harm the company's reputation and tank stock value if investors lose confidence. They might start doubting the company's ability to manage its artists or worrying about more drama down the line. That uncertainty could lead to stock prices dropping, impacting everything under the company, including other groups, and Hybe being criticized for leaving investors in the dark with no relevant information coming from them. So they're not exactly innocent in this either. We also don't know if in the future, when NewJeans are free from hybe, investors will still want to invest in them. Their image has definitely taken a hit in this whole feud. Beyond losing investors' interest, if NewJeans wins this case, it could change the industry. An industry, insider said, once a precedent is set, there's concern that others might try to nullify legitimate exclusive contracts to suit their own interests. What they're saying is that other groups could be influenced by NewJeans and try to pull the same move for their own benefit. Lastly, after seeing how this all plays out, agencies might change contract dynamics, making things way stricter for future groups.